Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today is a special program about how attorneys can become small claims arbitrators in the New York City small claims court system. And our guest is the president of the Small Claims Arbitrators Association and also a partner in the law firm of Bora and Goldstein, Darren Marks. And in his legal work, he concentrates in commercial litigation and also real estate litigation. Darren, welcome to Law You Should Know.
Thank you, Ken. Thank you for having me.
I should also mention that we're going to offer CLE credit with this show. Just listen at the end of the show for the code number, and we'll tell you what you can do to get CLE credit. Darren, aside from your practice of law, you also head the Small Claims Arbitrators Association, and that's made up of the small claims arbitrators of the various small claims courts of the city of New York?
That's correct, Ken. About 2 years ago or so, my co-founder, Avi Naveh, and I decided to fill the void that was left when the prior association dissolved by making a new association for small claims arbitrators.
And you've also taken upon yourself to recruit more small claims arbitrators and provide some training for them.
Absolutely. The small claims court is what people refer to as the People's Court. It services all 5 boroughs with day court, afternoon court, and night court sessions that typically have calendars of over 100, 150 cases per calendar. And people come there without lawyers seeking justice or a day in court. And there's typically only there's only ever one judge in the courtroom and one court attorney. And for people who want to be heard or want their day in court, if it was one judge presiding over every single case, people would be coming back several times before they can actually get before a judge. By having the small claims arbitrators in the court for small claims, where there's usually 4 to 7 arbitrators who can hear numerous cases, we are able to help the court get through their very busy calendars.
And it's the choice of the litigant if they want to go to before the judge and preserve their right of appeal, or go before the arbitrator is going to act as a neutral and render a final and binding decision.
Absolutely. As I explained to the new arbitrators that I train, being a small claims arbitrator is much like being a U.S. Supreme Court justice and my wife, by the decisions being final and not subject to appeal.
And binding.
And binding.
And can any attorney become a small claims arbitrator?
The answer to that is yes, but with conditions. The general condition is that the attorney be in practice for 5 years or 2 years if they work for the court system as a court attorney, be in good standing, and have the desire to want to serve and do this valuable public service.
And so it doesn't matter if a lawyer works in the library, if they're a litigator, if they're a senior attorney who's been practicing many years, or they're a relatively new attorney, as long as they've exceeded that 5-year requirement.
Exactly. There's no requirement that you be a trial lawyer or a litigator or a transactional attorney. What makes the arbitrators great is the fact that there is just such a diverse group of individuals who bring their own perspective. Even if they've never have stepped foot in a courtroom, they've all gone through the training and mostly apply their legal training from law school and being admitted to the bar to their daily work, even if they're not lawyers. So by coming in to the small claims court as an arbitrator, you get to sit as a neutral. And if you are a trial lawyer or litigator, it is helpful to help kind of polish your advocacy skills, because for once you're not sitting as an advocate on one side of the via the other, you're now sitting in the middle as a neutral, and you get to hear how plaintiffs and defendants represent themselves in court.
And of course, their different views about a situation, and I would imagine also enhances your listening skills.
Well, absolutely. The greatest part about being an arbitrator, on top of the fact that you're helping people, is that helping people get through their tough situation, which brought them to the small claims court to begin with, is that you are now sitting there and you get to listen to both sides. You get to either try to help bring resolution or bring finality by making a decision.
And there are courts in each of the boroughs.
That's correct. All 5 boroughs have a small claims court. And Manhattan actually has 2 because they have the Harlem Justice Center as well.
And an attorney does not have to live or work in New York City or a particular borough to serve as an arbitrator.
That's true.
And you can also, again, choose, as you mentioned before, a day or afternoon or night session of the court.
Yes, there's an arbitrator's. It's a voluntary position. There's no compensation. You get to choose what times and days work for you. We are right now with the association on the cusp of releasing our website, which is going to help automate the scheduling process. So an arbitrator who's a member of the association will be able to go onto our website through their phone or through a desktop and select what days and times work for them, subject to court approval, schedule themselves, which is going to be helpful to the arbitrators who don't have to wait for an email from the court clerks asking if they need arbitrators. It's helpful to the court clerks who don't have to reach out because the arbitrators can now will be able to self-schedule shortly.
And tell us about some of the skills an attorney will learn in the training process.
Okay. In the training, we cover the basics of what is small claims court, what are the jurisdictional limitations of small claims court, how is small claims court different than other courts, because in small claims court, the standard of review is different. It's substantial justice that is looking to be done, which basically means it's somewhere between Justice Cardozo and the guy who sold me my car. It's not all the way at one end or the other. It's something in between. It's trying to get to the bottom of facts and law without the technicalities and nuance of that go into when you have a trial and the admissibility of evidence and those types of technicalities. We go through the structure of small claims court. We go through the technical nature of making sure that the parties who show up for an arbitration sign the consent form. They sign the proper documents. How does an arbitrator commence an arbitration? How do they handle the parties? How do they conduct their arbitration? How do they conclude their arbitration? How do they issue their decisions? Also, arbitrators, besides serving as neutrals, serve another very viable function for the court, which is the arbitrators serve as referees for inquests. An inquest is when one party, the defendant or the defendant on a counterclaim doesn't show up, and so the claimant or the claimant on a counterclaim, it now doesn't have someone there to have against them for the day of court. So they're not just automatically granted a default judgment for everything that they sued for. They have to make the claimant or the claimant in the counterclaim has to make a prima facie showing that they are entitled to what they sued for. This goes to the arbitrators who now are serving in the function of court referees, because the inquests are a review and report to the judge who signs off on them. So we go through a lot of the technicalities. We talk a little bit about style, about how an arbitrator should conduct an arbitration, how they should handle the parties. It's fairly comprehensive.
And about how long does that training take?
The training session is about 2 hours. We've been very, very blessed by having just a deep resource in the courts of judges who have been involved in the small claims court. Judge Arthur Angoran wrote the book, the manual for small claims arbitrating, some 20 years ago, and that book is still almost entirely on point with law and otherwise. We have Judge Gerald Leibovitz and Barbara Jaffe who have been very helpful with the trainings. We have Judge Nicola Moyne, who has also been very helpful in running trainings. So we're very, very blessed about the number of judges we've had show up. At our last training, we had Judge Moyne and Judge Jim Klein's present to help run the training. We've had Judge Angoran, Judge Jaffe, Judge Leibovitz, and really this all wouldn't be possible without Judge Tony Canataro, who's a supervising judge for all of the civil courts in New York County, who has been nothing but just supportive and enthusiastic of bringing back the association and getting more arbitrators trained. In the last year, I think we've trained close to 400 to 500 arbitrators.
Darren, we've got to take a short break now. When we return, we'll talk more about the training, the benefits of being a small claims arbitrator, and how an attorney can apply for the program. And there'll also be the code for possible CLE credit for attorneys who qualify. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denisi, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking to attorney Darren Marks, who's the president of the Small Claims Arbitrators Association, about how any attorney who's been practicing at least 5 years can apply to become a small claims arbitrator in any or all of the 5 boroughs of the city of New York. You don't have to live in the city, and some of the value of performing that service. It's really a form of pro bono work. If someone serves, usually how long is the court session, each session they're sitting for, Darren?
Ken, the average time in court for a small claims day is in the mornings it's from 9 to 1, afternoons from 2 to 5, and evenings from 6 to 9 or so, depending on the court. Sometimes they go a little later, but most of the time it's about a three-hour commitment in the courtroom.
And about how many cases would an attorney general handle in that time period?
It really fluctuates on the day and the court and the calendar. Some days I've been the only arbitrator to show up on a light calendar, and I'll handle half a dozen inquests and 4 to 5 arbitrations. Other days it's a few inquests and no arbitrations. Other days it's more arbitrations, 7, 8. It just depends on the day, the time, and again, arbitrations are unique to each case. So some arbitrations can take 20 minutes, others can take 45 minutes. We try to get through them as quickly as possible because, again, especially in night court when they have 150 cases on the calendar and 6 or 7 arbitrators and people want to be heard, you want to try to make sure, you want to balance the parties being heard, getting to say everything they want to say, but not waste too much time and be dilatory so that someone else doesn't get their time to be heard that night.
And as the arbitrator, you would be questioning the witnesses and the litigants to satisfy yourself so you have enough information to render a decision?
It depends on the case. Some cases the parties are very articulate and are able to present their case without issue. Other times you'll have a lawyer and someone who's less articulate, and you can ask questions as an arbitrator. You got to balance the fact that you're not a advocate for one side or the other. You can't really root for one side to win and one side to lose. You got to be fair. I had a arbitration about a year or so ago, and I'm listening to the parties talk. A professor with a PhD in furniture history sued a furniture retailer for a mid-century piece of furniture that he bought that he thought was a fraud. And I'm listening to the parties, both very articulate, talking, and I'm formulating my decision based upon the testimony and evidence that's being presented to me. And after about 30 minutes, one of the parties says something, is an in-passing comment that was telling that basically their side was not as genuine as it was led to be. And again, that's the skill of listening, because had I not been listening, I would have skipped that and made a different decision. But you give people a chance to speak, and they generally will answer the questions. They're not super complex cases. I've never seen a small claims arbitration that can't be resolved in one night, and generally within a half hour to an hour. But there are certain times where you get someone who is not a native English speaker who will try to give their side of the story without a translator. We try to get people translators as best they can, and you work through to ask questions. Some people have never been before a tribunal before, such as a small claims court, and they just want the case to be over and heard, and they'll come and give their side, and you, as an arbitrator, can help that person by asking certain questions to help get you the information you need to make your decision. But again, it's really balancing to make sure that you do not advocate for one side over the other.
And just as an aside, if someone receives a summons from the small claims court, it's a real legal document. They should respond to it and appear when they have to. Absolutely.
It is it can create a judgment up to $5,000. In some situations, for other causes of action, more than $5,000, in the sense that a person can be sued for multiple causes of action for $5,000 apiece. And if the party does not show up and a default judgment is entered against a defendant, the plaintiff can try to enforce that judgment.
And it could affect have many consequences for that defendant down the road.
That's correct.
And what are some of the very common or typical, cases? You mentioned one that was a little bit, I guess, atypical, but what are some of the common cases?
The common cases you get are a tenant suing a landlord for the failure to return a security deposit, two roommates suing each other for one owing the other money, a person suing a store because they weren't happy with the goods or services that were purchased, which is interesting because of the world we live in now with the internet and services such as Yelp and Foursquare and Google that have reviews. The commercial defendants in cases where a consumer is not happy with they went to a dinner and got food poisoning, or they went to a dry cleaner and their jacket got damaged, will go online and start trashing the defendant in reviews. And I've seen an uptick in the party being sued counterclaiming for defamation and those types of claims, and which leads to settlements in the sense that the commercial defendant will typically will agree to a reimbursement of some sort in exchange for the claimant removing the negative Yelp or Foursquare review.
But also, if a store or a person is owed money, they can seek to collect it through the small claims court.
Yes, that's another common one you see, especially during the small claims day courts. You see stores who provide services and do so on credit or weren't paid right away, and they'll sue the people who haven't paid them.
Or even on a personal loan.
Loans are a little different because of I haven't really seen the personal loan ones. I think those tend to go to a different part of the civil court that deals with the banking issues and debt. And
what I meant the loan between two people, but what about also a property damage case of a car?
They occur. They're not super frequent. The ones I tend to see, especially in Queens and Brooklyn, are ones where against the city of all defendants, where their car hit a pothole and their rim got damaged, or they got a tire blowout, or you see all sorts of cases. You see some personal injury cases. Some people try to sue for medical malpractice. That becomes a little bit more difficult because you need an expert, and that's very expensive to get an expert to come to court. So you'll see just a variety of cases. Another popular case is parties suing for what's called the TCPA, which is a federal statute, the Telephone Consumer Protection Act, where the federal government created a private right of action in the local state courts for parties who received robocalls, unsolicited commercial calls that are started with a robo-dialer and an automated voice, or a robo-fax. A very cute story of a case that I had was someone who had sued a travel agency claiming that he received 7 unsolicited faxes from this travel agency, but a very not even so close look at the document showed that it was 7 copies of the same document.
I see. We just have a moment or two left in the program. This is like the people's court. And so it allows people to get justice through the court system, so that we don't want people to exercise self-help.
The small claims court is, as you said, it's the people's court. It allows everyday people who feel that they're being taken advantage of to use the court system to seek justice. You don't need a lawyer. The filing fees are very low and can be waived if someone is in financial straits and cannot afford the filing fees. An application can be made to waive the fee. It also is a court that provides fairly expedient resolution. Most small claims cases go away within a year. They're very quick. They're not like other cases that can last several years. Unless, of course, you want to be heard by the court, that can take much longer than if you go for an arbitration. But most cases are resolved within the first or second appearance.
And I'm sorry, very briefly, and after they've heard each other's case, do some people just reach an agreement?
Settlement is fairly common, especially when people are coming to arbitration. Coming to arbitration is showing a level of pragmatism because they're waiving the right to an appeal, even though appeals are very expensive and not typically taken. It's showing that people just would like to get finality and get it done, and that shows a level of common sense. And at that point, people who are demonstrating that type of common sense would like to sometimes take their future and their destiny into their own hands and make an agreement that they're happy with, as opposed to an arbitrator making the decision.
And the decision is issued later on, not in front of the litigants.
Yeah.
Darren, our time is just about up. Tell us how someone can get in touch with you or your organization to find out more about becoming a small claims arbitrator.
My email is Darren, Darren, at smallclaimsarbitrators.org or www.smallclaimsarbitrators.org. I'd also want to, Ken, thank you very much for having me on your show. I hope that people who are interested in becoming arbitrators sign up. And also, I would like to take a moment to thank Judge Canatero and the entire staff of the Civil Court who have been just so helpful in bringing this along and helping bring back this organization that serves such a vital purpose.
Okay, thank you very much for running the program and being guests on the show. The CLE code for today is SCA3214. That's SCA3214. It's through the Nassau Academy of Law. Contact them at nassaubar.org for information on getting the CLE credit. You may have to pay a small administrative fee. Please join us next week at the same time for another program on Law You Should Know. If you missed any part of this program, you can hear the podcast at no charge at nccradio.org.